So how long are you gonna stay? Okay, well then I'll be. They have the lead. I'll still be here.
Into that briar patch of Professor Darcy's. Good luck with that. Enjoy the role.
Right.
Wait.
Oh, you mean how much? I don't remember. Oh, his or her offer. I don't remember.
You know, there's no such thing as a 10-minute break. This is well-known organizational development principle. There are always 15 minutes no matter what. Okay, where were we? Covenants.
Servitude in general.
Easements and covenants. So what's an easement?
The right to use somebody else's property.
Right to use the property of another. Almost always we are talking about rights of way. But there are other kinds of easements that we consider a little bit. 99% of all easements are what we call express easements. What does that mean?
They have to be in writing and they require notice. And they have to be intent, there has to be an intent.
There's writing, notice to whom? To the servient estate holder. Yeah, the burdened estate. How do we accomplish notice? If it's an express easement, we accomplish notice by going down and recording the document.
It has to be recorded.
Yes, that provides constructive notice. So an easement, a deed of easement is one of the documents that must be recorded. But other kinds of notice suffice as well, inquiry notice and actual notice. In writing notice and
Intent to run with the land.
intent to run with the land. So the easement should say what? In order to make it run with the land. I intend for this to run with the land is one way. Another way,
Heirs, successors, assigns.
shall be binding upon heirs, successors, and assigns is the traditional way of doing it. That means we intend for it to continue to bind successive owners. So we say it's attached to the land. When somebody else buys the property, they're buying the easement with it. So, most easement, and we've also got to have a description of the easement, of course. If it's a roadway, it needs to be described. How wide, for example. The more specific the description, the fewer problems in the future What's the rule about exceeding the scope of the easement? If you hold the easement, what do you get to do with it?
You hold the easement.
You're the easement holder.
Oh,
We usually maintain
but you're making the property better.
You must maintain the road if it's a right-of-way, for example. Right. Can you pave the road
it. Yeah.
if it's not paved?
Yeah.
Yes.
Reform.
Can you widen the road?
No.
No.
Can't see the scope of the original.
No, that would exceed the scope of the easement. Generally, we're talking about the dimensions of the road side to side. How do we terminate an easement? Right. We can agree in the original document, this easement is for 30 years. This easement is for 50 years. We can agree in a separate document. The grantor, the owners of the servient and the dominant estates may agree to terminate the easement and record that, and that will happen. Other ways. Merger, what's merger?
When the holder of the serving estate becomes the owner of the dominant estate.
When the estates merge, then the easement disappears. You can't have an easement on your own land, when you're on your own behalf. So when the estates come under common ownership, the easement goes away. Estoppel, did you say?
I did.
Yes.
Well, that's not a way of terminating it, is it?
Abandonment.
Abandonment is the other one. Remember, abandonment means that there must be a clearly expressed intent to abandon. The fact that you go off and leave it for a while doesn't mean you've abandoned it. You pretty much have to say, I don't want it anymore. An act of abandonment is expected. Now, it doesn't always happen. Maybe the easement's been sitting there, the right-of-way's been sitting there for 150 years now, and nobody's tried to use it. Maybe we would also say that's an abandonment. But normally, we're looking at very clear conduct on the part of the easement holder. In addition to express easement, we have a few others. If it's not express, it is implied. So, what are we talking about?
Where there's prior use by a common grantor.
So, easement implied from prior use. We don't have anything in writing, but we've got a long practice. And so what's the practice that we're looking for?
Continuity and necessity.
Common grantor, first of all. At one point, the property was in one piece. Have to have that. The use had to be occurring when the property was all in one piece. So before the property was divided, look to see if there was, that's the prior use we're looking for. Then ask yourself, is the easement benefiting one part of the property? And if that is still the case, if it was benefiting the property before it was divided, and it still benefits the property now that it is subdivided, then we say, by implication from prior use, we recognize the easement. Another one?
Necessity.
Easement by
Yeah.
description.
Well, the other implied one is necessity. Easement implied by necessity. What's the necessity easement?
Landlocked.
Landlocked.
and it becomes unrecorded.
And we mean absolutely landlocked. Here we want reasonable hardship if the defendant is not allowed to continue. But the necessity easement means it really must be necessary. This assumes, however, the law of property assumes that you are entitled to get on and off your property by land if possible. So the fact that you can get to it by a boat usually doesn't excuse the person who owes you the easement by necessity. They need to let you cross their land. Again, has to have been under common ownership. Strangers do not owe you an easement across their property, even if it's the only way out. Georgia allows you to do a private condemnation action if your neighbors are not kind enough to sell it to you anyway, if you really, really need it. But the common law doctrine of easement by necessity has to do only with the people that used to own the property that you now own. They owe you the easement. And you had at least one case that said the easement can lie dormant and then reemerge. So these are the easements by implication. We've also got
Prescriptive easement.
prescriptive easements. What's that?
It's like having the, through adverse possession, it's like adverse possession or easement.
Yes, this is adverse use, not adverse possession, but adverse use. That is open, continuous, open and notorious, continuous for the statutory period, hostile, non-permissive, and actual, yes, has to be actually used. Does not have to be exclusive. It's the only difference. And the result of a long period of such use means that this use is confirmed. Does not mean that title passes, only that an easement is granted. And then we have easement by estoppel. This is also called irrevocable license. The use begins, it's permissive use in the beginning. It's a license in the beginning. What's the characteristic of a license? A license can be revoked at any time. If I'm just giving you permission to use my driveway for a while, I can revoke that at any time. On the other hand, if I stand by and watch you pave my driveway, I cannot then say, well, I'm revoking your license, because you have relied upon my permission to your detriment. And I have allowed it. I have acquiesced in it. So we grant you what we call an irrevocable license, also an easement by estoppel. My conduct has allowed you to improve the property. So I can't now, in fairness, deny you the right to use it. So the court will confirm it as an easement. Questions about easements?
What about engross, is that?
Oh, engross, right, good point. Appurtenant and engross. So what's an appurtenant easement?
Two parcels of land.
Two identifiable parcels of land. One is benefited, one is burdened. If we can identify both a servient and a benefited estate, and they will be adjacent to each other in almost all circumstances, then we call that an appurtenant easement. What do we know about appurtenant easements?
Benefits a
They run
specific,
with the land.
benefits a specific person.
Cannot be severed.
No, they benefit a specific piece of property.
They can't be severed.
Can't be severed. Can be merged, can't be severed.
Can be transferred.
Can be apportioned. So if I've got the right to drive across your property and I decide to tear down my house and build an apartment building, do all of my tenants now have a right to drive down your driveway?
Yeah.
Yes. Yes, if it's an appurtenant easement, then the assumption is it's exclusive and apportionable. Now, easements in gross. This is when a person or a corporation is the easement holder. There isn't a benefited adjoining parcel. When I give the utility company an easement across my property, the electricity may be going to Michigan. There's no parcel adjacent to mine that is benefiting from this easement. So we call that a commercial easement in gross. Same with the easements that the utility company, that the city puts under your land to run the sewer pipes and so forth. These are easements in gross because there isn't another piece of property that we can identify that's being benefited.
So there's never gonna be a dominant in an easement in growth.
We all benefit, right. The idea is everybody gets the benefit. Are easements in gross apportionable? Can TVA, which has condemned the easements of many, many people in order to put the power lines across, now sublease the easement to the fiber optics
No.
cable people?
Yes.
You can, on what?
It is exclusive.
Commercial.
Whether or not it's an exclusive easement in gross. Or did the property owner retain some use rights? When TVA condemns an easement, it condemns the exclusive use of the easement, and therefore it is allowed to take the profit from that would otherwise belong to the property owners when they let the fiber optics folks put in their cables. There are also personal easements in gross. I was going to give Mr. Kirkbride fishing rights on my farm up in North Georgia. I've decided against it, but at one point in the semester I was going to give it to him for life. Right? That's a personal easement in gross. Can he give it to anybody else? No.
And it attaches to just him and not the land.
Just to him, not the land, exactly.
With the easement and growth, do we need to look at the intent of the grantor, like for the test? Required to distinguish?
Well, you always look to the intent of the grantor. But also, is that in terms of a personal easement?
Yes.
Yes. Look at the way it's written.
For ambiguity?
Well, is it given to a person, or is it attached to is it given to the owner of a piece of property, or is it given to a particular person?
It was given to a particular person.
If it's given to a particular person and there is no property that we can find, right to come and fish in my lake, and I write it down and I record it for your lifetime. That's a personal easement in gross.
In that example about access to your land for fishing is for one person, if the land, say that the land is passed down to your heir and they do not want that person to fish, the person still is allowed to fish, right, because it's for their life?
Yeah, the grant was for life. So it's the life of the grantee that we're looking at. And it would, and the heir, the successor, would have to honor it. That's the advantage of a personal easement in gross. You may be able to bind subsequent property owners. They would need to have notice, of course. So,
Who would you have?
the subsequent owner. Even for an easement in gross, you still got to have intent, notice, and the writing.
So I take it we don't need to know nothing about like negative easements or anything like that.
Well, what about negative easements?
Stop you from doing something.
So is that like a,
Blocking use, limiting use.
is it a, I'm confused about the difference between that and the covenant. Are those the same thing?
What?
Negative, a covenant is a negative easement?
No.
One is like air, water.
Do I have a right to prevent you from building your tall building if it interferes with the sunlight that comes across your property onto mine? No, that would be a negative easement, and they're disliked by the common law. Especially once we got to America. Because the doctrine of ancient lights had caused a lot of trouble in England. Prevented a lot of development. So we took it away. States have, in certain circumstances, reinstituted it by statute. You can get a solar easement in Georgia. You can get the right not to build. I mean, you can negotiate that, and it's recognized. But by and large, the common law of negative easements at common law were disfavored. That's why we got covenants. Because the courts wouldn't enforce the negative easements.
So will it be on the exam?
What?
Will it be on the exam,
What?
the negative easements?
I don't remember whether that question is on the exam or not. So you'll
it's a
just have
multiple
to,
choice
you'll just have to deal with it.
So it's multiple choice, if it is multiple choice. Got it.
So what else can I tell you?
Give me a second.
Can you review fee simple and all that?
So, wait a minute, you said negative, so the easements are gonna be the affirmative servitude, right? It's an affirmative servitude.
Yes, easements tend to be affirmative servitude. Covenants are the typical device used for restricting use of property. They come from contract law, not from property law.
Because it's an agreement.
Because it's an agreement between two parties. The way that we make them property transactions is to insist that they accompany a transaction in land. Otherwise, they're just a contract. So can I contract with you to restrict the use of your land while we're both owning adjacent property?
Yes.
Yes. And that would be enforceable between us. In order for it to be enforceable to successive owners, we've got to attach it to the land. And we do it in two ways. First of all, we insist on horizontal privity between the contracting parties, which means that there has to be a transaction in land that accompanied the making of the covenant. And we say that the act of transferring the land creates the horizontal privity that enables us to attach the covenant to the land.
So this means if I own 2 lots and I sell you one of them, is that what you're?
That would be a time to create the covenant. If we go ahead and do the transaction, and then we meet a few days later and negotiate the covenant, it is too late to attach it to the land.
Okay. It has to be with the transaction.
Right, it has to be with the transaction. If we do that, we have to create another transaction. And the covenant has to touch and concern the land. So we have to have intent to bind with the covenant. Does it have to be in writing?
Yes.
Yes. has to accompany a transaction in land that meant creating horizontal privity between the grantor and the grantor, the promissor and the promisee. What else do we need?
Let's touch concern on that.
We need notice to whom?
To the survey.
Don't just tell me we need notice.
To the survey and estate.
Notice to the survey and estate, yeah. Doesn't matter if you know whether you got the benefit of the covenant, it matters if you have the burden. Because you're the one who's giving up otherwise permissible use of your property. What else?
Let's touch concern on that.
Must touch and concern the land? What does that mean?
It has to affect the use of the land itself, not the people.
Has to be a burden and a benefit.
Restricts or devalues, restricts the use or devalues the survey and estate in some fashion. And
Something that increases the value.
enhances the use or the value of the benefited estate, the dominant estate. Remember that you must analyze down both the benefited and the burden side in order to do a full covenant analysis. Did we talk about expressed intent to run with the land? We talked about it when we talked about easements. Same with covenants, must be an expression by the grantor of an intent to bind successors. So again, we can say, we intend to bind successors, heirs, and assigns. We can say we intend the covenant to run with the land. But the writing itself should reflect an intent to run. Anything else we need for a real covenant?
Horizontal and straight vertical.
Oh, yes, we need vertical privity. So what's that?
To transfer the land from the land owner to their, to whoever they transfer.
Yes, this is looking at successive owners. We have the original covenanting party. We must ensure that there was horizontal privity between them. Then we look at, down the burden side, who have been the successive owners. And down the benefited side, we look at who are the successors. In order for the burden to run with the land, we must have strict vertical privity between the original covenanting party who undertook the burden and the present owner of the property, or the present possessor of the property. And strict vertical privity means the present holder of the property must own all of the interest of the predecessor. So if you have property in fee simple absolute and you transfer it to me in fee simple absolute and there's a covenant on it, are we in strict vertical privity?
Yes.
Yes. If I own a piece of property and there's a covenant on it and I rent it to you, are you now in strict vertical privity?
No.
No. So the tenant may be obligated to comply with the covenant, because we might call it an equitable servitude, but isn't bound by this covenant because there's no vertical privity there. I would be still bound and liable in damages.
And that's because the full interest doesn't transfer.
That's because my full interest did not transfer. So usually what happens if there's a breach of covenant? What happens?
What's the remedy?
Do I lose my property?
You have to pay damages.
Well, maybe, unless the covenant says so, no.
It's in a contract, so it depends.
It's a contract, so you're looking at damage and injunctive relief, generally speaking. Now remember, there is such a thing as promissory.
That's not what's
Well, there is that. But there is also a promissory restraint on alienation, a promissory restraint is one of the categories. So it can be found in covenants. And those covenants are not valid.
So that's the promise not to transfer the property.
I promise not to transfer the property, and if I do, it will be null and void, and I make this in the form of a covenant. That is not enforceable either.
Or in a will, right?
Or in a will. Right. Any way you do it, total forfeiture won't fly. And sometimes there is a forfeiture provision in a covenant. But generally speaking, unless the covenant itself provides for forfeiture, that's not going to be the result. So it's not like a fee simple determinable. If I break the condition, somebody else gets the property. I'll keep the property, but I'll be required to pay for breaching the covenant, and I may be enjoined to comply with the covenant.
We touched on it briefly, the doctrine of implied, reciprocal, negative servitudes. We'll expect we'll see that related to subdivision.
I would not rule that out.
Could you please repeat what he said?
The doctrine,
Might you encounter implied reciprocal negative servitudes in
residential subdivisions.
subdivisions on the exam, and I said I would not rule that out.
Servitude, it's on page 577.
We talked, it has to do with planned unit developments, condo associations, homeowner associations, and certain kinds of subdivisions. Remember, we talked a lot about the fact that it is easier to restrict the use of property in such places when there is a homeowners association in place, when there is a condo association in place. Many, many, many restricted covenants often accompany the ownership of a condominium. And you'll be told by a board how to comply with the covenants. And so there's not always a clear, everybody is operating under the same restrictions. And everybody is getting the same benefits, is the theory. That's why we say they're reciprocal. Now usually they're expressed in the condo association deeds, and it's not, we're not in a position of having to imply them. But it will be in the condo covenants that you signed when you moved in. So you can say, in terms of who's benefiting and who's burdened, everybody's benefited. Everybody's got to comply with this restriction, and everybody gets the benefit of it. So it's all reciprocal.
Or a burden, no?
Or burden, yes. Both. Everybody's carrying the same burden, everybody's reaping the same benefit.
So I got it, the start of my notes say you do not need strict vertical privity to enforce a covenant when you're on the benefited side. Is that,
Correct.
can you explain how that works? Because I know if you're on the burden side, you need strict,
When you transfer the land.
Right, so suppose that I've got a covenant with my neighbor, that he will not build bonfires in the backyard during the fall when the forest fires are likely to start.
Okay,
And I rent my house to you.
okay.
And you go out one night and you see a bonfire over there. Are you entitled to enforce the covenant? Yes.
Okay.
You've got the benefit. And we don't need strict vertical privity to give you the benefit.
Okay.
We do need strict vertical privity to pass the burden on. Anything else?
Can you review your fee simple? Just estates in all the estates. some restraints on alienation. Ooh, and what's that rule? Servitude.
You keep your list and check it off, okay?
Start from the beginning.
What, Terrence?
Start from the beginning. Every day.
Okay. We are talking about freehold estates. That is to say, we are not talking about landlord-tenant, which is coming next semester. Freehold estates. There are two kinds. There are fee estates. And what else?
Life estate.
Like,
Life estates. Also, in this category, though we didn't talk about it, is terms of years. So if you should see, it's not O to A for life, it's O to A for 30 years. Treat it as a life estate, it's a term of years.
doesn't that get into landowner tenant? I mean, tenant, land, owner? Wouldn't that be considered a lease if it's term of years?
No, not if it's granted this way. If I leave to you in my will the use of my property for 30 years, I don't want, it's not for life, it's for 30 years, then it's equivalent. The fee estates are what?
Fee simple,
Fee simple,
absolute.
absolute.